Welcome everybody to our webinar this evening. Here is Deanna to introduce this workshop and the series as a whole. Deanna?
Thank you, Keegan. Good evening, everyone, and thank you for joining California Lawyers for the Arts for Intersections, Art and Law at the Border, our second annual symposium. Tonight is the second of 6 weekly virtual webinars that will be presented through July 30th. My name is Diana Cervera, and I am the program manager for California Lawyers for the Arts San Diego. On the call, I'm joined by our special projects coordinator, Sara Gonzalez, who co-led this project and helped make tonight possible. I would also like to highlight our statewide staff members, Alma Robinson, our executive director, Gloria Ruiz Oster, our newly appointed Southern California director. Before we begin with our program today, I would like to take a moment to acknowledge that the land that we are on is native land. The border region of San Diego, Tijuana is the ancestral territory and homeland of the Kumeyaay Nation, both past, present, and future. We recognize that we are guests in the Kumeyaay's homeland, and as guests, I extend my respects and gratitude to the many indigenous peoples who still reside here and call these lands their homes. Border zones have been described as open wounds, arbitrary divides delineating the meeting of nation states, defining that which is left in and that which is left out. Characterized by a constant tempering and transmutation, a border region is a delicate and complex ecosystem fraught with the push and pull of political attitudes, global debates on migration, and intricate networks of power. Artistic and legal adaptations manifest in this liminal space. Artists challenge us to investigate what exists between and beyond the walls, to reimagine our world as one where many can coexist. On behalf of California Lawyers for the Arts, I'm pleased to welcome you tonight to our second panel. So I'll hand it back to Keegan to begin our program. Thank you for joining us.
Thank you, Deanna. Before we begin, I'd like to introduce California Lawyers for the Arts and explain some of the services we provide. California Lawyers for the Arts is a statewide nonprofit founded in 1974 that serves artists and arts organizations. We currently have offices in San Francisco, Berkeley, Sacramento, Los Angeles, and San Diego. We offer 3 core services for the arts community. The first is our LRIS, which is a state bar certified lawyer referral and information service. LRIS matches creative artists with attorneys throughout all of California. We also administer the California Inventors Assistance Program to assist independent inventors and small startups with their patent legal issues. Our Arts Arbitration and Mediation Service provides low-cost community conflict resolution services which seek to resolve disputes for involved parties outside of court. Finally, we have what brings you here this evening, our education programming, where we offer a variety of workshops, symposia, and legal conferences on various legal topics for arts and arts organizations. Please visit our website, calawyersforthearts.org, for more information. Next, a message from Jonathan Gluss of the San Diego Commission for Arts and Culture.
Hello, my name is Jonathan Gluss. I'm the Executive Director of the Commission for Arts and Culture for the City of San Diego. I'd like to welcome you to this second annual Art and Law at the Border Symposium. On behalf of the Commission, I'd like to thank California Lawyers for the Arts for their partnership, their leadership, and for producing this important event. I'll be attending along with you and look forward to virtually meeting you in the coming days. Welcome to the conversation.
Thank you, Jonathan. This video is aimed at helping anyone with employment legal issues, especially after the effects of COVID-19. With us tonight is Arlene Yang, a partner at Brown Law Group in San Diego. Arlene specializes in employment law and business litigation. She provides employers with preventative legal advice on issues including employment issues arising from the COVID-19 pandemic, wage and hour matters, independent contractor classification issues, discrimination, and reasonable accommodations. She has many years of experience with nonprofit arts organizations and currently serves as board president of transcenDANCE Youth Arts Project. Also joining us is Michael Parme. Michael is a trial lawyer and partner at Haight, Brown & Bonesteel. He represents clients in civil actions arising primarily from commercial liability and business disputes, employment-related claims, professional liability, and complex multi-party construction and environmental litigation. He currently serves on the board of directors for California Lawyers for the Arts. With introductions taken care of, let's begin our presentation. Michael?
Hi, everyone. Thanks for joining us virtually, and we're really sorry that we can't meet in person this time around, but I just want to give a shout out to our CLA staff who've done a tremendous job moving the Intersections program to a virtual platform and bringing us all together. There was a tremendous amount of work associated with that, and they all deserve a lot of congratulations for the execution of this great program. My colleague Arlene and I are going to be talking about a number of topics today, and I just wanted to kind of give you a roadmap of what we're going to be talking about today. Arlene's going to start out talking about mitigation of risk and federal leave laws. I'm going to do a sort of quick and dirty on unemployment compensation and the existing and then new since COVID-19 programs that are available to people. I'll do my best to kind of triage some of the questions that we've gotten in advance of the program. I'll also be talking about how the workplace has been impacted by the recent awareness of the Black Lives Matter movement and the national protests and what that means. We'll be talking about safety in the workplace. So I'm going to kick it over to Arlene for our standard, very lawyerly disclaimer.
Great. Thank you, Michael. So again, my name is Arlene Yang. Yeah, so just so you know, this is sort of a legal information presentation. We're not providing advice on any particular legal issue. And if you do need specific information, you should talk to an attorney on your own to get specific information. So just to repeat, I work at Brown Law Group. We generally counsel employers, but I understand from the registration that a lot of you are actually artists and independent contractors who are not employers. So I'll try to talk about both things that both employees or independent contractors and employers need to know. But just so you know in advance, the slides are kind of geared towards the employer point of view. So let's going right into some of the basic things that you need to know about employment law if you're just getting started is that how important wage and hour laws are in California. So there are a lot of basics that employers really need to know, and as an employee you need to know that these are important as well. Having a timekeeping system is important. So there needs to be a record of if someone's being paid by the hour, they need to have records of when they started work, when they ended work, when they're having their lunch break. All these requirements are required by California law. And so there needs to be an accurate written record of what happens during that period. Also, calculation of overtime. If you may work in other states as well, California has different rules from the federal government and it's more restrictive. So there are more requirements that apply in California than some other states. Also, something that a lot of employers don't really know about is business expense reimbursements. So most people are familiar with the concept. If you have to drive somewhere for your job, not commuting, but you have to drive from your place of work to another place, the employer needs to reimburse your business expenses in terms of paying for the mileage. These kind of requirements also apply to using your cell phone. If you have to use your personal cell phone for work, your employer is supposed to reimburse some of that use of the cell phone. It doesn't have to be the whole thing. Typically, most employers will just have a set amount saying, well, we'll reimburse this amount every month based on your cell phone use. And then we've seen with the pandemic and a lot of people are moving into working from home, there are also business expenses there. So I'm using my personal computer, my personal internet to perform work for my employer. The employer is supposed to be reimbursing some amount to account for the fact that the employees has to use their own equipment and their own internet to perform work for the employer. And then another issue that often trips up employers is related to, unfortunately, a lot of people have to get laid off at this time, and there are a lot of rules about when someone has to get paid. So the law is in California, if someone is terminated on Monday, on that Monday, the employer has to provide all the wages that are due on that day. So if it turns out, especially now where people are not in person, if someone's getting terminated on a Monday and the check can't get to them until Tuesday because it has to be FedExed, often we'll just advise the employer just to make the last day of work to be on a Tuesday. So you would notify them on Monday and then they get paid on Tuesday. The reason why this is required is because the employee is owed 1 day of pay for every day they don't get the pay that they're owed, so up to 30 days worth. So it can get very expensive very quickly. Some of these seem like not very important requirements, but they're all penalties associated with all of them. So we always advise employers to try to keep on top of these rules so that they avoid liability. And so this is the reason why We also encourage employers to have employee handbooks. It's not required by law, but having these policies, making sure that the employer has the policies and then everyone has a way to understand what they are, can help to avoid violations. So some things that are required is to have a written sexual harassment policy, and also having a record that you've told the employees what the meal period and rest breaks are and how to take them. It's helpful to have something in writing.
We have a question that came in about the pay period requirements for when you get terminated.
Yes.
The question is, so if I was terminated on the 16th and my wages for the previous week came until the next pay period, which is almost 2 weeks later,
Right.
I'd be owed a day of pay from the 16th until the day the pay arrives?
Right. So the employer is not supposed to wait until the next payroll cycle. They're supposed to have that pay ready to go, and that the day of termination, you get the final pay. If someone is resigning, then I can't remember if it's 72 hours. There's a little bit more time for the employer to get the paycheck to the employee. But if the employer is initiating the layoff, then they have to pay at that time. So the options for employees, what they can do is they could talk to the employer, let them know that there was a mistake. They can also go to the labor commissioner. So if you look up the California Labor Commissioner website, they have instructions on what to do if you need to make a claim against your employer.
Does that also apply to part-time workers?
Yes. So then we'll just talk a little bit about sick leave. As you may know, there already were several kinds of California sponsored sick leave. So there was some paid sick leave that's accumulated, generally 1 hour for every 30 hours worked. And there was also some parental leave or new parent leave, so that there was some leave available that way. But now with the pandemic, we have two new kinds of leave that you may want to be aware of. And that is emergency paid sick leave, and then the Family and Medical Leave Expansion Act. These are temporary types of leave. So it's only a period from April 1st to December 31st, 2020. And it should apply to all private employers with fewer than 500 employees. So it's a very limited kind of leave. I'll tell you a little bit about it. The Paid Sick Leave Act, it's if someone is quarantined or experiencing COVID, it's up to 2 weeks of paid leave, and it's up to $511 a day. So the employee has to be quarantined or experiencing COVID symptoms. This is a situation where the employee is unable to work or telework. So it's for some reason they can't telework from home either. There is this kind of leave available. There's also a child care or caring for individuals subject to quarantine leave, also for 2 weeks. That would be at 2/3 the rate of pay and up to $200 a day. So this is where the person generally is having to care for a child because the school or childcare is unavailable. And this is a type of leave that has to be paid for by the employer initially, and then they can get sort of a credit on their payroll taxes. So in the end, hopefully they won't be out of pocket, but they have to pay the money out up front. And now the Emergency Family and Medical Leave Expansion Act is a new kind of leave for the first time. It's expanding FEMLA. Most people have heard of the Family and Medical Leave Act, which provides unpaid leave, but this instead is a paid leave. It's generally related to someone who has to care for a child under 18 because school or the child care is closed due to coronavirus. And this can go for up to 10 weeks, up to 2/3 of the pay. So what's been interesting is that there can be an exemption if the employer has less than 50 employees and that it would jeopardize the viability of the business. That's an exemption just for the first leave about the Emergency Paid Sick Leave Act. So it's a little bit complicated, but so just to be aware that there's this additional type of leave that's available through the end of the year. One thing that employers are supposed to also do is provide a poster from the Department of Labor, which explains it. So you can look on their website, and that kind of gives a summary of what kind of leave is available. Okay, and then we'll talk about the layoffs and furloughs. So this is just to be aware, we have record unemployment in this country. So many people have faced unemployment, either layoffs or salary reductions. And so this is just a reminder that when employers make termination decisions, they should be having a business justification for it. there should be no way to, like, for example, if someone is saying, well, this employee is over 65 years old, and we think that having these people working is going to be endangering their health, so we're going to lay them off. That would be a discriminatory reason because it's based on their age and not some other business reason. So employers just need to keep in mind that when they're making layoff decisions, even though California is an at-will state, generally the employer is entitled to let anyone go at any time. They still need to make sure that the reasons that, if they have a reason for letting that person go, it should not be a discriminatory reason. So that's just something to keep in mind when there have to be layoffs that are made. And we're going to turn to Michael, who's going to talk about the hot topic of unemployment, which I understand there are just a lot of questions about.
Thanks, Arlene. I'm going to be talking about unemployment compensation and what unemployment kind of is from like a sort of broad perspective. And I'll do another little disclaimer here, which is in making an assessment of whether somebody is entitled to benefits, it really is a very fact-intensive and situational or circumstance-intensive inquiry. So I will at this point plug California Lawyers for the Arts as a great resource if you feel like you have unjustly been denied benefits or your particular case warrants a second opinion, or you just are having trouble navigating the system and that issue is particular to you. I would suggest that you reach out to California Lawyers for the Arts and have Keegan put you in touch with somebody who can assist you individually, assuming that you qualify. So with that said, I'm going to be talking about unemployment compensation. In the context of the current moment, there's a couple things that you can quickly take away, which is these significant changes to the existing system. And we're going to talk about these in depth, but they're all laid out here. You used to have to wait 7 days. That's waived. The work search requirement, which required people to be actively looking for work, has been relaxed. There is the federal pandemic unemployment compensation, which is the widely reported in the news $600 a week federal benefit, kind of known generally as like a booster shot for those who have lost their jobs due to COVID-19. That's a very temporary program that's going to be expiring at the end of this month, unless it's extended. And we're going to be talking about the expansion of traditional workers' compensation beyond simply W-2 employees that used to be covered to different areas of the workforce, including the self-employed, small business community, and 1099 independent contractor / gig workers in the economy.
Are employers required to state the reason of termination in their termination letters? All right, how are we to know that they aren't firing based on something that's protected, but then they just make up a different excuse?
Employment in California is at will, and it's generally regarded as at the employer's discretion, fair or not fair. The employer can make a decision to terminate somebody for really no reason at all. So, Arlene, do you want to expand on that?
Yeah, there's no requirement to have a basis for the termination in the letter. And sometimes we advise employers not to because that could open up some other can of worms. So if the employer doesn't state a reason, they have that right not to.
Real quick and dirty, if you don't know what unemployment compensation, and it seems like I'm speaking a different language, it's a program that's administered in California by the Employment Development Department. It is a program that is funded by employer-paid taxes, and it applies to no-fault terminations. That means that if somebody is terminated for cause, in other words, they did something inappropriate or there was a specific reason that they were terminated, violated a policy, et cetera, unemployment compensation does not apply to them. It also does not apply to those who voluntarily quit their job.
If a college student who still depends on their parents but has worked for the last year is now unemployed due to the pandemic, can they apply for unemployment?
Yes. The answer is yes. Unemployment insurance existed pre-COVID, and generally today, as we sit here, you are eligible for traditional unemployment insurance if you have a W-2 income and any of the following criteria apply. Your employment status has been affected by COVID-19. And you are fully or partially unemployed as a result. You are fully or partially unemployed for any reason. Your child's school is closed and you need to miss work to care for them, or you have a previous unemployment insurance claim that expired. That's traditional unemployment insurance. Back in April, the legislature enacted the Pandemic Unemployment Assistance Program, which is best thought of as a layer of unemployment insurance that is being placed on top of the existing system and is more inclusive, and in some cases results in additional payments. So under the traditional system, 1099 business owners, independent contractors, the self-employed, the folks in the gig economy who are living basically 1099 to 1099 were not included under the traditional system. The PUA brings those people into the fold. And the rationale behind this is that the government saw that there's this huge segment of our workforce that are not W-2 employees, and that they also were hurting because of COVID-19, and there needed to be some kind of safety net. So the theory was PUA picks up the people that the traditional unemployment compensation would not otherwise cover. So basically envisioning it as two pots. They'll either get the benefits this way, they'll get the benefits this way. The PUA is administered through the EDD as well. It's in California. It's administered through the states. It's a benefit that's paid through the states, but it's a federally created layer of compensation in addition to the existing system.
If you work in an essential service industry, like a grocery store, and you quit because you are concerned about being around so many people during a pandemic, can you still apply for and receive benefits?
Yeah, that's a really good question. My response to that would be that under the traditional rules, unemployment compensation is not available if you quit your job. However, there are limited exceptions in scenarios where somebody is exposed to a risk of harm, and due to the fact that they are exposed to that risk of harm, it would be unreasonable for them to work that job. And that would essentially be the test that is applied. So even though generally and traditionally the answer would be no, you can envision a lot of circumstances on a kind of case-by-case basis where somebody who is, for instance, someone who's immunocompromised or has other pre-existing conditions that would make working in a grocery store an absolutely untenable situation during COVID-19 would be appropriately within the scope of the program.
Can you briefly describe the difference between being furloughed and being laid off?
The logistics of the difference between being furloughed and laid off are actually more theoretical than anything. But when you are furloughed, there's an expectation by the employee that he or she will be hired back because it's seasonal work, or there is some reason to expect that, you know, business is bigger in the summer or whatever, and you go back to the amusement park. So people get furloughed in those types of scenarios. A lot of people were furloughed in COVID-19. The practical distinction between being laid off and furloughed is one that's more theoretical in the context of unemployment compensation, because what matters is that you've lost your job. So just kind of closing out our discussion here, there are a lot of issues that are raised by the unemployment compensation and the current system. Most notably, whether it's going to be extended, particularly in the context of the $600 payments that the federal government is currently making on a weekly basis to people who are eligible under either UI or the PUA. But also, there are some real problems with the current system that the Congress is aware of and trying to address, but for perhaps political reasons, they haven't been addressed yet. One is that it is becoming very common that in places like San Francisco, where it is very expensive to live, people who are business owners also have supplemental W-2 income. And there is a whole group of people that have this situation that are basically ineligible for PUA because they have a W-2. And that W-2 is usually kind of a side hustle. And the common wisdom is that this is something that needs to be addressed by Congress, needs to be addressed in any kind of subsequent measures that are taken to respond, because like I said, the theory was you're either W-2 or you're 1099, but what about the people that are both? It appears that they have fallen through the cracks, and it's a very sort of disappointing and unfair situation. So also wanted to just quickly address a couple issues that are some of these other ones that are listed on the slide we've talked about. But I did want to also mention, you know, what happens if you take unemployment compensation benefits and you're also using public assistance programs? Well, in the case of Medicaid or CHIP, the Children's Health Insurance Program, those programs are not affected. Your eligibility for those programs are not affected by the money that you receive through unemployment compensation. However, if you are in the SNAP program, if you're receiving other entitlements, your income which, by the way, is taxable income, which means the money that you get from the workers' compensation system, you either need to make a specific decision when you apply for them that you want your taxes withheld, or you need to be setting aside that money or figuring out how you're going to pay the tax bill next year. That is all taxable income. So that can impact your benefits if they're based on your income threshold. Also wanted to mention that with respect to grants, people who have received grants, you have to look at the terms of the individual grant, and whoever provided the grant can probably give you the best guidance as to how increases in your income, because a lot of people are making more money presently than they were at their jobs because of the $600 booster shot that the federal government is giving. You would have to look at the terms of the individual grant or whoever provided the grant to get information to determine whether it impacts your eligibility for it. So, and now, having kind of spent enough time on this issue for the time being, I'm going to turn it over to Arlene, who's going to talk about developments with regard to California's AB5.
Okay, thanks, Michael. So yeah, talking about AB5, contractors versus employees. I think by now most people have heard of AB5, which is a new statute that came into effect starting this year. And it was quite the talk of, there was a lot of talk about it, certainly at the end of last year, beginning of this year, because it really codified a change in how people can be considered an independent contractor or an employee, making it a lot more difficult to be considered an independent contractor. So just to give you a little bit of basics about where this came from, there was a case back in 2018 called Dynamics. And that was a case where there was a package delivery company who was paying their drivers as independent contractors, and they wanted to be treated as employees. When the California Supreme Court looked at the case, they came up with this ABC test. So it requires that the independent contractor has to be free from the control and direction of the hiring entity. They have to perform work outside of the hiring entity's usual course of business. And then they have to be customarily engaged in independently established trade, occupation, or business. So if we look at the package delivery company, their business is delivering packages. The drivers who are delivering the packages, they're part of the same business. They fail the ABC test and they have to be treated as employees. The California Supreme Court said, well, the other example could be the plumber who comes to the package delivery company. The plumber's not going to be told what to do, down to the last detail by the package delivery company. It's a different kind of work and they have their own business. So those are the two ends of what independent contractor versus employee is. That's a new test. Before, there was a lot of different factors that could be considered, and it was a little bit more flexible. So this has really changed, and it's really impacted a lot of people working. And I think there have been a lot of unintended effects. So I think the legislature thought they were trying to help people by making more people employees, but many people would really prefer to be independent contractors. And unfortunately, they can't do it. Even if the employer and the employee want to do it, they have to, if they don't meet this ABC test, then they have to generally be considered an employee. But I did want to let you know that there are a number of exemptions that could apply. So for certain types of professions, there are some exemptions, like certain kinds of real estate people. There are also some other exemptions. There's one called the professional services exemption, and that could include that are related to arts groups. We have freelance writers, graphic designers, fine artists, photographers, and also grant writers, music and marketing, and human resources administrators. So for some of those professions, there may be an opportunity to be treated as an independent contractor, but there's still a number of multi-factor tests that have to be met to be considered an independent contractor. And some of them we're already familiar, but just to note some of them, if there's required to be a business license, then the independent contractor has to have it. They have to be customarily engaged in this type of work that they're doing and hold themselves out to work for other people. And they have to customarily and regularly exercise discretion and independent judgment. So there are a lot of different factors, but generally what it is the more factors that relate to being considered an employee, then the more likely they'd be treated as an employee. So this has had to lead to a change in how many companies and nonprofit organizations are treating their workers. And then there's also business services provider exemption. And that also has many, many factors that have to be considered. But among them, the business services provider must be a sole proprietorship or a partnership, limited liability company, a partnership or a corporation. And then there are a lot of requirements, just ensuring that to make it clear that this is a separate business. One factor that it's very difficult sometimes to meet is that the business service provider must be providing services. They can't be providing to the customers of the company or the employer. So that sometimes makes it difficult to try to contract around and have a separate company if they're providing services. So an example might be if an organization is providing educational services to students and then they hire a separate company to be the teachers, there may be some difficulties in creating an independent contractor relationship. That's kind of the basics. The reason why employers need to care about these issues is, and if you're an independent contractor who's misclassified, the issues can become very expensive for the employer to correct if there's a problem. So for instance, I was on the board of a dance company, and this was a long time ago in another state, but they were hiring their dancers as independent contractors. And then one of the dancers got injured. They filed a workers' comp claim, but they weren't an employee, so they weren't officially entitled to workers' comp. But then when the state agency looked into it, they realized that the dance company should have been hiring them as employees and not independent contractors. So then there's a lot of expense to try to clean it up. And, so that's why employers need to kind of pay attention and make sure that they're classifying their employees correctly. Yeah, so I don't know if Mike, you've talked to a lot of people about these issues. Did you have something you wanted to add as well?
Just kind of circling back on one of the things I talked about earlier, which is a scenario where someone's a 1099 independent contractor and a W-2 employee. It's always worth, if you are receiving a 1099 and you consider yourself an independent contractor, consider this 3-factor test, this ABC test, and consider whether you believe yourself to be truly an independent contractor, or if your employer has just said you're an independent contractor because it doesn't want to provide benefits. And that's really what AB5 is about, at least ostensibly, to cure some ills in the system where employers were getting the benefit of the labor without providing proper benefits to people. So, there's a huge amount of people out there right now that are misclassified under this test, and employers are trying to get their stuff together to bring their business within the confines of this law. But it's always worth, if you are an independent contractor, considering, am I truly an independent contractor or am I an employee? And if you're an employee, you may be entitled to unemployment or other benefits as a result. And you can always consult with an attorney to figure out what your rights are.
There was a question about if there are any payroll tax implications for AB5. So I guess employers are supposed to be withholding payroll taxes for employees, and they're not doing it for independent contractors. So there can be problems if they haven't done it. They've misclassified the employee.
All right, I'm just going to talk, talking about what does the workplace look like now in this moment where there's increased awareness through Black Lives Matter or of various types of protected classes throughout society, and we have this increased awareness. What does it mean for the workplace? First of all, not as much as you might think is sort of the short answer. That you don't throw the employee handbook out the window just because of the Black Lives Matter movement. Employer policies probably remain the same, although it's probably advisable to go back and revisit those and update them if they don't reflect the current moment. A couple of things to know from the employee side of it. When you're in the workplace, the general rule is that there is no First Amendment. And that, what I mean by that is you can say whatever you want in the workplace, but you are subject to the consequences that your employer has laid out through policies. So most employee handbooks have rules against having political slogans. Most employee handbooks have words against offensive speech. All these things are still in play, and they don't just get abandoned because we have an increased awareness of the Black Lives Matter movement. Same with the right to assembly. There is a constitutional right to assembly. You can absolutely walk out of your job, but the employer does not have to keep you on. If you walk out on your job, same rules apply as always have. Even if you're going to protest, which is a constitutionally protected activity, the employer can decide that they don't want somebody who's going to protest while during work hours, and that is a legitimate position. Certain types of discussion are protected in the workplace, such as discussions among employees about working conditions or about things of that nature may be protected types of speech. So just drawing a little bit of a distinction. And we're lawyers, and there's an exception for everything. So it's a good time for a refresher on discrimination and anti-discrimination policies that apply to the workplace. The process of bringing a claim for discrimination starts by going to a agency, either the state or federal agency. In California, we have the Department of Fair Employment and Housing. As the state agency, we also have the Equal Opportunity Commission. As the federal agency, note that there are time limits applicable to filing such claims. A charge of discrimination in California, currently it's 3 years from the date of the conduct that is discriminatory. Discrimination occurs in the workplace when there is either disparate treatment or a disparate impact. Disparate treatment is when someone is singled out or treated in a discriminatory way because they belong to a protected class, and there is some kind of adverse employment action associated with that activity. Disparate impact is a little different. It's when an employer's policy that seems benign on the surface actually hurts one type of person in the workplace more than others. And when that policy affects someone who belongs to a group of people in a protected class, and there's an adverse employment action that results, there may be actionable discrimination, which means you can go to the agency, file your charge. The agency will say, you have a right, they'll investigate, probably give you a right to sue letter, and then you can go file your lawsuit. That's how discrimination claims work. By the way, discrimination isn't just race. In California, there's a lot of different types of protected classes, and I'll run through some of them. Race, color, national origin, religion, sex, disability, age, citizenship status, genetic information, sexual orientation, marital status, medical conditions such as even things as common as depression can be the basis for discrimination. Keep in mind that when we talk about discrimination, perhaps you're not a person of color, but you belong to some other type of protected class. And when we talk about discrimination, it's discrimination in all forms. So the law is very broad, and it's important to be aware that there are lots of different types of protected classes in any given workplace. Also wanted to briefly talk about retaliation, which is extremely important in this moment, because as people come to awareness about issues of race and inequities in the system and systemic racism, there may very well be people who in any workplace who go to a supervisor, go to an HR department and say, I think these practices that are going on in our workplace are unlawful, or they complain about practices that they believe are unfair or discriminatory or in some way hurting others or them in the workplace. Maybe they're participating in an investigation of some kind of unlawful discrimination or allegation of discrimination. Or maybe they're just simply requesting accommodations for religious practices or disability. It is critical to realize that that is a protected activity that they are engaged in, and it is absolutely unlawful to terminate, to provide even a warning, or do any kind of disciplinary action or demote them based on that activity. It is everyone's right to engage in protected activity as long as it's acknowledged as protected activity. And in this moment where so many people are coming to awareness of inequities and systemic racism, it's important to realize that those people who voice concern, who are engaged in making these complaints or bringing this to awareness, are engaged in protected activity, and they cannot suffer any kind of adverse reprisal as a result. So if they are subject to some kind of reprisal, that would be actionable discrimination. They can file a lawsuit for retaliation. A note on reasonable accommodations in the COVID era. And it's important to realize that there may be people that are immunocompromised, people that require special accommodations because they have an existing medical condition that the COVID climate makes their working situation different. Maybe they need to work remotely. Maybe somebody who has multiple sclerosis or celiacs or something like that doesn't want to be in the workplace, and they are entitled to reasonable accommodations. And that's usually something that employers would get guidance from a human resources expert or a lawyer about. Just kind of closing out our discussion, as people return to the workplace from a legal perspective, it's important that employers and employees are on the same page with respect to what it takes to have a safe workplace. And that includes creating safety protocols, being aware of the availability of personal protective equipment, being familiar with rules of physical distancing, in some cases employers doing health screening, which is not necessarily required, but in some contexts is a good idea. Certainly having a sanitation plan is a good idea. And in general, I would say the most important thing for people getting back to work successfully is probably having as much knowledge as possible. And also from a legal perspective, it's important to have the right knowledge. And the right knowledge is coming from places like the CDC, it's coming from state guidance, it's coming from county guidance. And California has a great resource. There's a link here. You can click on this interactive map, go county by county, and see which counties are kind of hot for COVID and see what the current statistics are on a day-to-day basis for your own local area. I realize we have people throughout California, so I'll just leave it at that. Sort of, you have the resources to track the data and know when cases are spiking, or circulate this information to your coworkers so that they're aware, so that everybody's on the same page about the risks that are presented.
Thank you very much. So let's watch a very quick closing video from our Executive Director, Alma.
Thank you for joining our second annual symposium, Intersections, Art and Law at the Border. My name is Alma Robinson, and I'm the Executive Director of California Lawyers for the Arts. The COVID-19 pandemic provided us with an opportunity to reframe this symposium as a series of virtual programs. These will all be posted on our YouTube channel, along with other useful art law webinars. Many thanks to the San Diego Commission for Arts and Culture, the California Arts Council, the law firm of Perkins Coie, and other members of California Lawyers for the Arts for making this program possible. Thanks also to our San Diego Steering Committee, to the speakers for their excellent presentations, and our staff in Southern California for the many hours they dedicated to producing this series. If you have specific legal questions, please contact our lawyer referral service for assistance. We also offer a range of alternative dispute resolution services and an ongoing schedule of educational programs on various legal and business topics. I hope that you've enjoyed tonight's program and encourage you to browse our website for future programs and other information, including a list of COVID-related relief resources. Please consider joining CLA in order to help support our work as we advocate for the arts as an essential sector of our society. Thank you for your participation.
Thank you, Alma, and thank you, Arlene and Mike, for your time and expertise. Please see our website if you'd like more information about our memberships, programs, and services. Thank you very much, and have a great rest of your evening.